The defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself. That he then tried to rape her.
My client is the victim.
I'll tell you what it sounds like to me. He's intending on getting the upper hand. He goes over there. He knows that if he calls the police, she's in violation.
Things spiral fast in this one. Straight out of a real-life crime thriller. An obsessed ex is accused of breaking into his former partner's home, tearing the door right off the hinges, and violating a no-contact order in the process. Instead of owning up, he tries to turn the hearing into a jealous cross-examination, grilling her about who she's been seeing. But Judge Simpson doesn't miss a beat. He dismantles the guy's story piece by piece, exposing every flaw in his self-pity act. You can literally see his confidence collapse on camera. The big question is, should someone like this even walk free? Because honestly, it feels like we're watching danger in real time.
And good afternoon again, Your Honor. Miles Drew on behalf of Mr. Busick, who's approaching my right. And can you please state your name for the record?
Ryan Michael Busick.
All right, thank you. Go ahead. This is your motion.
Thank you, Your Honor. At this time, people are going to be requesting our original request of a $50,000 cash surety bond. In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning to people. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw broken drywall. The door was off the frame. The lock, the deadbolt was still in the lock position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then proceeded to chase her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, you see that they both, it was raining, and they were both covered in rain, I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the two calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation of accusing her of cheating and infidelity on the jail calls. And then the next day, when he's arraigned, after he's arraigned, he calls her again, violating his bond. And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim, and it's very concerning to people given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request, and believe that a personal recognizance bond was an abuse of discretion, Your Honor.
Response.
And Your Honor, we would admit that there was a call that occurred on the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean iChat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who is in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have two children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges, And I have expressed not only to Mr. Busick, but to the family, the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness. As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work. And even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he is the provider for these children, and they get their health insurance through his job, and that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail. So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record. And I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for any reason.
What would you have understood about that, counsel?
I mean, even if your girlfriend did cheat, there's no world where breaking down her door and forcing your way in is remotely justified. If the accusations are true, that's way over the line. The lawyer lays everything out clearly, and you can literally see Judge Simpson's face say it all. What am I hearing? This isn't some traffic ticket. This is a no-contact violation tied to a possible assault. That kind of combo instantly triggers any judge's alarm bells. Once a no-contact order is in place, it doesn't matter if she called, texted, or even invited him over. Legally, he can't be there. Period. That's where these cases get complicated. Emotions don't matter in the eyes of the law. Only actions do. And Judge Simpson knows how easily situations like this can spiral or turn into repeat offenses if the court gets too soft. That I'm not saying the guy's guilty. But if even half of this holds up, it's serious. Hopefully, Judge Simpson doesn't pull any punches if things take a turn here, because this is exactly the kind of case where leniency can backfire fast.
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to make those calls. We would be asking for a $25,000, 10% with the tether.
But he's still, from the allegations, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. After creating, some damage, or allegedly creating some damage to the premises, and things not going well because now you're in custody. You're told by the magistrate not to have contact, and what does he do? He has contact, and about the same thing that the allegations are about.
Right. I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are concerning. We can test them as it relates to the case.
Tell me how I can even be sure that he's going to follow this court's conditions.
Well, I think you have his family sitting right here in the courtroom, that they're accountable, good members of our society that are going to be looking out and holding him accountable. They have, financial interests involved in this case as well. They are living with Ryan. He has no prior record, which I think speaks to the fact that they raised him pretty well up to this trying point here. And I think that the tether, was put in place after these phone calls, and there's been no issues with the exclusion zone. So I think in that respect, the tether is working, Judge. And I think you have members of the community that will be looking out to assure that your court order is followed by Mr. Busick. And I think this is a real wake-up call for him, quite frankly. This isn't a situation he's used to being into, given his clean criminal record. And I think he's standing up a little bit straighter now after this and understands just how much is on the line after having a stern talking with counsel both last night and prior to court today about the severity of the situation that he's in here, Judge.
In the 14B case, isn't there a no contact?
There is a no contact order in place.
So what's he doing there? I mean, that's the part that's troublesome to me. He has a case in which he's the alleged victim, right, counsel?
Correct.
He knows there's a no contact provision, right?
Yes. Well, the no contact provision would run to the defendant in that case, which is the complaining witness in this case.
How it works. That's not my point. My point is, why is him knowing that? Why is he at her residence?
Well, Your Honor, I would say that I think, these no contact orders, I mean, he shouldn't have been seeing her, but this is a 10-year relationship that goes back to when they were 16 years old. They have children in common. While I certainly would have liked if this was handled.
So that's all fine and dandy. But he knows she's not supposed to have contact, right?
Well, he believed the condition was dropped. But I mean, I would agree that he should not be having contact with her.
Where would he get the idea that it was dropped?
I'm not sure, Your Honor.
I don't believe that for a minute. I mean, he knows she's not supposed to. I mean, I'll tell you what it sounds like to me. Sounds like to me he's intending on getting the upper hand. So he goes over there and he can basically, in essence, force her to give whatever answers he wants, because the one thing at least he knows or thinks is that if he calls the police, she's in violation, I'm not.
No contact means exactly that. No contact. It's black and white. And the fact that this guy still reached out says everything about how little he respects the court's order. What blows my mind is that he's actually asking for a cash bond, like throwing money at it somehow cancels out what he's accused of doing. Judge Simpson's been on the bench long enough to spot the difference between someone who genuinely understands the gravity of their actions and someone just trying to sound remorseful. What complicates things here is the guy's clean record. No criminal history, nothing on file. That always gives judges pause because it's tough to tell if this is a one-off lapse in judgment or an early warning sign of something deeper. And now is suggesting a tether, as if that's suddenly going to restore trust or guarantee he'll follow the rules. You can tell Judge Simpson's weighing every angle carefully, trying to find that line between fairness and safety. Still, with no past record, it's a tough call. What do you guys think? If you were in Judge Simpson's seat, how would you handle it?
No, I don't think that that's the situation going on. I mean, when the police officers did bring up the no contact order on the scene, he said that he had thought it had been dropped. I mean, I think he's simply concerned about, these beliefs of infidelity, Your Honor. It's an improper way of going about it without doubt. But given that he has no record, he hasn't had any trying situations. He's only 26 years old. Any trying situations like this in his life, I would view this as kind of a one-off situation that now that he has the accountability structure in place with his family, being aware of what's going on, being in the courtroom here supporting him, that this type of behavior would not continue. And I expect him to comply with all court orders going forward, Judge.
Anything else from people?
Nothing. I mean, I just have concerns given what the court stated with the no contact order in the 14B case, and given that the victim in her interview with police at the scene states that they're separating. So I don't know why he would go to her residence to accuse her of this break-in and assault her. I don't understand. But nothing else from the people as far as this goes, Your Honor.
Right, and I think you know this, counsel. What I really should do is I should revoke his bond. He doesn't make it a day before he's violating the bond condition.
I understand the court's concern.
And
this is
not just, it's not. What is troublesome for me is that he violates a bond condition. And when we look at the transcript of what he's talking about in the very first part, it's just a continuation of what got him there in the first place.
And I think this, sorry.
Go ahead.
I was going to say, I think the stern talking to that I've had with both him and his family about the, concerning nature of these allegations, the phone call transcript, I think that he's been very receptive to my feedback, and I don't see that this being an issue going forward. This was, within a day of the incident, his emotions were still very, high in charge. It's obviously no excuse for doing what he did, but given that—
Counsel, that's part of my problem. Part of my problem is it doesn't seem that he can de-escalate, because he gets involved in this thing, gets arrested. This fixation that he has on this infidelity, even after he's arraigned, even after he's warned, admonished what he can do, what he can't do, within hours of that, he can't step back. He just can't.
I understand the court's concern. I would say, while I would not have advised him to send any of those emails to the court, the fact that he's reaching out to the court, not to her, is some indication of change from the, Friday before.
No, it's really not.
He's not reaching out to her. I certainly would not have advised him to send those emails, and I have instructed him going forward not to do anything like that and to run anything he's doing with these cases through counsel going forward.
Listen.
Even the emails are concerning. In the emails, he's trying to get her in trouble, trying to use this as leverage against her in the other case. And he just can't stop. Even if it's not contacting her, it's this continued obsessive feelings towards this victim.
I'm certainly not pleased with the emails being sent, but I would note that it does appear that there are potentially bond violations on the other case. That's not a concern for this court here. But it's not like he's making up and frivolly.
Why is it even his?
Your Honor, I have no good explanation for that.
Tell me what your client's purpose in sending those to the court. What was the purpose in sending those to the court?
Wanted to alert them of the bond violations that have been alerted of in his case, Your Honor. It's not anything that he's proud of, but, he was going to change his actions going forward.
It's not my court. He knows what court it's in. Why is he sending it here?
I think people commonly get confused about the 14th.
Counsel, look at the very first email. He's not confused because he's real clear about what he thinks is happening with her defaming him.
I meant the confusion about 14A or 14B, Judge. I understand.
But I'm saying, why did he send it here? I'm not the judge. He knows it. He's not confused about what court it is at all. Is he going to tell me that if I put him under oath that he thinks he's sending it to the right place?
Yes, he would.
I know there is no way. Why is it coming right now?
I sent it.
When were those videos taken? When were those videos taken?
About a month ago. And that was.
She's got a winter sweater on in like May? Really? So if you had them for a month and you think you're contacting that court, what took you so long?
There's no excuse for the timing.
No, what took him so long? This is his story. He's trying to convince me that he can behave.
Would you like me to speak?
Go ahead.
So I didn't want to contact the court because, yes, we were working on things, and I spoke in front of you, and I believe that the no contact was dropped so we could start to work on things. I came in front of you and said that during her case one day.
Your Honor, I would note that it was charged as a felony case, and I know you typically sit on the PCC docket, so you may have been a judge that appeared on that case at some point. My understanding is that currently it is just the misdemeanor domestic violence charge that is still pending against the complaining witness, but I do believe it was a felony case where it's possible you would have been a judge that sat on that docket.
And Your Honor, if the court does remember, you were on that case for PCCs, but the people had declined to address the no contact and change it, given concerns of the case.
If you were looking to report these month-old alleged bond violations,